masterclass today. Before we start, I want to give you two important pieces of information. As always, we have simultaneous translation, so all those interested in following the masterclass in Spanish, please go to the globe icon, and then please raise all the questions that you may have on the Q&A. Okay, I will greatly appreciate it. My name is Fernando Peláez. I am LexLatin COO, and today we have our masterclass focused on real-world legal artificial intelligence, legal agents, and the future of legal practice. Imagine for a moment that you arrive at your office and your legal research is already done. The contracts review themselves, the repetitive tasks run automatically while you focus on what really matters: thinking, strategy, and serving your clients. This isn't science fiction. This is agentic artificial intelligence, and it is here to forever change how we practice law. What are legal intelligence agents? Think of a super smart virtual assistant that never sleeps, never gets tired, and never forgets a detail. But it is not just an assistant that answers questions. It is a proactive collaborator that researches for you. While you sleep, it analyzes your case law, finds precedents, and prepares detailed reports. Monitor your cases. It constantly watches them and alerts you about important changes and new opportunities. Processes documents. It reads contracts, identifies risks, and generates executive summaries automatically. Anticipates needs. It suggests strategies based on patterns it detects in case developments. We're not talking about simple automated searches. We're talking about systems that think, analyze, and act autonomously within the parameters you set. It offers opportunities for your productivity. Multiply your work capacity without increasing your hours. A single lawyer can handle the workload that previously required an entire team. For your competitiveness, offer faster, more accurate, and cost-effective services. Respond to your clients in real time, not in days or weeks. For your growth, free up time for high-value activities like business development, strategy, and building client relationships. For your life, reduce routine work hours and focus on the intellectual work that truly excites you. Today, our expert guide is Damien Riehl. Many of you already know Damien. Damien is one of the most authoritative voices at the intersection of law and technologies. He isn't just a theorist. He's a lawyer technologist who has lived in both worlds. He currently leads product design and development at vLex, where he is integrating artificial intelligence technologies to change the legal workflows and power legal data analytics. Damien has a vast experience. Damien, the audience is yours.
Great. And thank you so much, Fernando. And really, I'm glad to be here. Thank you so much for having me. Today, I'm going to be, of course, talking about what everyone is talking about, and that is large language models and artificial intelligence. And I speak quickly, so apologies in advance to my interpreter. I'll try to speak slowly so that we can be able to be understood both in English and in Spanish. I have been a lawyer since 2002. As part of that work, I worked for judges at both the state level and the federal level. I also was a litigator. I litigated for about 15 years with a large law firm where I represented Best Buy in much of their legal work. I also represented victims of Bernie Madoff. I also sued JP Morgan and Countrywide over the mortgage-backed security crisis of 2008. So I did high-profile bet-the-company litigation, but I've also been a coder since 1985. This is me at age 10, and this is my Commodore 128 I used to be able to code. My mom loves this photo. So the number of lawyers that are also big law refugees, were also judicial clerks, that are also know technology, there aren't many people in that Venn diagram. So in 2015, I pitched Thomson Reuters to say, here's legal technology that I think can change the world. You should build it and hire me. And they were dumb enough to do that. And then these days I work for vLex, as Fernando said, which used to be known as Fastcase and DocAlarm, where we have a massive data set worldwide. We have 1 billion documents. That is cases, statutes, regulations, motions, briefs, pleadings, not just for the United States, but 100 countries worldwide, including many countries in Latin America. And so my job is maybe the best job in the world, where I get to be able to use that 1 billion legal documents as a playground to run large language models across those, and to be able to build what was otherwise unimaginable even 5 years ago. And if you have the data, that is, if you have the Latin American cases, statutes, and regulations, you can do that magic. If you don't have those data, cases, statutes, and regulations, you cannot, and it hallucinates. I also have been doing a lot of work with legal data standards. So let's talk about AI. What AI is matters a great deal, but it matters less to you. What matters to you is that in December of 22, GPT 3.5 beat only 10% of humans on the bar exam. That's impressive, but it's not as impressive as only a few months later, GPT-4 beat 90% of humans on the bar exam. And that's worth repeating. GPT-4 beat 90% of human lawyers on the bar exam. And by the way, this is a lot of lawyers say, well, that's fine because the practice of law is not the bar exam. And I agree with them. But the real question is how much of the work that we as lawyers do every day and bill our clients for every day is actually far easier than the bar exam. And that's why everyone is talking about large language models. Another aspect is you see that was March of 2023 with GPT-4. That was before reasoning models like O1 and O3. And the technology has gotten much, much better since March of 2023. So I know the guys who did this work, beating the bar exam using GPT-4, and I've encouraged them to do that with O3 and the other thinking models. And I would bet that if they did it with those thinking models, the number would be closer to 99% or perhaps even 100%. So this is human baseline of performance. And even 2 years ago, large language models beat humans in reading comprehension, language understanding, predictive reasoning, things lawyers do. And GPT-2 in 2017 was only a preschooler. GPT-3 was about an elementary schooler, ages, say, 8 to 12. GPT-4 was about a high schooler, maybe up to age 18. And it even at age 18, it beat the bar exam. O1, a reasoning model, beat PhDs in physics. O3, another better reasoning model, won the Artificial General Intelligence Prize. And so the question is, as we go forward, where is each of us in this list? And how soon before large language models blow by even the best of us? So this is, again, human benchline. Most AI experts thought that the ARC-AGI prize wouldn't be beat until 2039. And even then, they thought it would just be about 50% of humans. But it didn't take till 2039. It only took 3 months. And they actually beat it in December of 2024. And by the way, this is the average human, someone you could buy on Mechanical Turk. And DeepSeek is a Chinese model that is free and open source. And it almost beats humans. And this is December of 24. So here we are 6 months later. And I think DeepSeek may actually beat Mechanical Turkers these days. So this is a different benchmark where this is the graduate level Google proof Q&A. So this is PhDs in their field. These are questions that you can't Google to get the answers. And you could see back in June of 23, it cost $50 for 1 million tokens, and it did very poorly. But then only a few months ago, February of 2025, Gemini beat PhDs in their field. And by the way, it did it for much less money. You could see back in 23, the cost was $50 per 1 million tokens. And in February of 25, the cost is 50 cents per 1 million tokens. So the intelligence is exponentially going up while the cost is exponentially going down. So what are we going to do with this intelligence? Well, AI, the intelligence, is a tool that solves problems, but we often think of them in that order. We should be saying, what are the problems we as lawyers want to solve? And what are the tools that can solve those problems? And it turns out that large language models are very good at solving these problems. I want AI to blank. Whatever finishes that sentence is a problem that AI can solve. So when I was a litigator, I would want to solve the problem of creating counterarguments and good facts. So I took an actual lawsuit where a bunch of coders sued Microsoft and OpenAI over ChatGPT. What the coders did was they put a bunch of code into GitHub, and Microsoft ingested that code to create GitHub Copilot. And the coders said, wait, all of that is MIT licensed. So by ingesting the code, you breached our contract. This is a breach of contract lawsuit. So I thought it'd be fun to have ChatGPT argue against its owner, OpenAI. So I took OpenAI's motion and I said to ChatGPT, here's a motion to dismiss. Create a list of counterarguments against OpenAI. And it faithfully did that. Some of the things that it argued was saying that where OpenAI said that the coders lack standing, ChatGPT said, no, they have concrete injuries that are linked to actions. That is a good legal argument. Then I said, for each of your legal arguments, create the elements of the claims. That is what the coders need to prove to be able to prove breach of contract. And here's the output. To show standing that I'm able to sue in court, a lawyer must show that the client was injured, that the defendant, the bad guys, caused that injury, and that a court can redress that injury. That is the actual non-hallucinated elements needed to prove standing. Then I said, now give me facts that the coders could argue to prove each element, and do that for every single claim. And here is the output, where they said OpenAI said that the algorithm is so widely used that it decreased the market demand for my coding. Therefore, I can sue. I, as a coder, do have injury in fact. The defendants caused that injury, and a court can redress that injury. And ChatGPT said you could also argue that the coders lost a big contract with a big client who went with OpenAI's product instead. Injury, causation, redressability. Then I said, create a bunch of questions for my coding clients to help them win. And here's the output. Have you suffered economic loss? Can you show me lost business opportunities, lost revenue? Can you give me documents? Can you show me a link between the dates that you lost your business and when OpenAI started using your code? These are good questions that I'll want to know the answer to so that my clients can win. Everything here took me less than 1 minute. So the question is, how long would that have taken one of your associates? And if they bill out at hundreds of dollars per hour, how are you going to charge for 45 seconds worth of prompting? And what if you happen to have 1 billion legal documents, all the cases, all the statutes, all the regulations, all the motions, briefs, pleadings? And what if you happen to work for a software company where the users don't have to be prompt engineers, but we simply bake that into the legal software? So you simply upload the motion and you get all of these good arguments coming out. What then? How are you going to bill for this work? And not only do you as a lawyer have access to the software, but also your clients, that is the corporations that we sell to, also have access to this software. So we've talked about the death of the billable hour for decades. And so far that death has been overstated. And I don't think the billable hour is going to die completely. But currently the billable hour is about 90% of income, and flat fees are about 10% of billing for most law firms. But I think that 10% flat fee is going to grow to 20 to 50 to maybe land around 60, which is where the big four accounting firms do about 60% of their work on flat fee. And only 40% of that work is hourly because it's too unpredictable. But 60% is flat fee. And I wouldn't be surprised if that's where lawyers end up, that the billable hour is not going to die, but large language models are going to make flat fees much more attractive for reasons that we're going to talk about later in this talk. Because with flat fees, if you shrink your cost, you increase your profit margin. And so this is a way that we can make more money with AI. By the way, everything I did was a public document. I did not put any confidential information into the system. I merely pulled public information from this public document. I also a problem I want to solve is finding logical inconsistencies in the other side's arguments. So where the other side said that the plaintiffs don't have an interest in restricting the study of the code that they put onto the internet, ChatGPT said that's inconsistent because it implies that by making the code freely available, they relinquished their legal interest, but they didn't. They put terms and conditions, the MIT license. That is a good legal argument. They also, where OpenAI said, you didn't say which OpenAI entity did what. ChatGPT said, listen, this is the same corporate family. These are joint actions. We can refine through discovery, but at the initial stages, a motion to dismiss would be premature. And this still blows my mind, that ChatGPT said, you could argue that my injury was the breach of contract itself. Because when OpenAI breached the contract, it was at that point that I lost control over the code. And this is a great legal argument that I wish I could say I would have thought of, but I don't think I would have after 15 years of litigation experience. In fact, this is such a good argument that I thought, did the AI make it up? Was it hallucinated? And so I went to the tool I'm building with my team at vLex, and I said, to show standing, can the breach itself be injury in fact? And because we have the cases, the statutes, and the regulations, it said, yes, here's a case that says that the breach of contract can be a concrete injury for Article 3 purposes. But I didn't stop there. I went into that case, Patel, and I went to the text of that case. And I said, and I found other cases that said, yes, breach of contract can confer standing for Article 3. This is an ideation machine. I would have never thought to make this argument, but because we have the cases, because we have the statutes, because we have the regulations, you could have ground truth, like you see on your screen, to be able to prove these arguments that I wouldn't have even had before AI. Another problem I want to solve is statutory logic. My law school professor said, if you want to understand a statute, put it into if-then statements. If this thing happens, then this is the result. So I thought it'd be fun to take an actual statute. This is New York's statute for falsifying business records. Maybe a former president was convicted under this. Maybe he's the current president. And I said, put this into if-then statements, and here's the output. If someone falsifies business records and intends to commit or aid and conceal another crime, then Class E felony. Now look at the text on the left, if you can speak English, and look at the text on the right. And I'll ask you 3 questions. Question number 1, which is easier for a lawyer to understand? Question number 2, which is easier for your clients to understand? And question number 3, which is easier for a computer to understand? Because computers work in if-then statements. So what if you hypothetically had access to 1 billion legal documents, all the cases, all the statutes, all the regulations? And what if you were to run all of them through this kind of prompt? We're on our way to computable law. Then I followed up by saying, now argue that Donald Trump violated the statute. And because you have the ground truth, the text, it says that if Trump intentionally committed a false entry in the business records and intended to commit another crime or conceal another crime, like maybe campaign finance violations, then he is guilty of a Class E felony. This is a reasoning machine if you have the cases, the statutes, and the regulations. I'm from Minnesota. Here I am in Minneapolis. So I asked ChatGPT, when will purple rain be in the public domain? Nothing more than that. When will purple rain be in the public domain? But it didn't start from scratch. I started with a copyright statute that relates to duration of copyright. And as a result, because I put that statute in there, it said, well, he died in April of 2016. The statute says life of the author plus 70 years. 2016 plus 70 equals 2086, but it doesn't stop there because the statute says that it goes to the end of the calendar year. So it doesn't actually enter the public domain until January 1 of 2087. That is the correct legal answer. If you have the statutes, as you see here. Then I followed up by saying, how about What a Wonderful World? Nothing more than that. How about What a Wonderful World? And they said, well, that song was written by 2 people. And the statute says a joint work goes by the last surviving author plus 70 years. The last guy died in 2010, and 2010 plus 70 equals 2080. But again, it doesn't end in 2080. It actually goes to January 1 of 2081. That is the correct legal answer. Now, if you're a client, your option number 1 is to ask your friendly copyright lawyer this question. Option 2 is to just ask a tool like this yourself and not even go to the lawyer. And that option 1 lawyer doesn't know why the phone didn't ring. My friend is a privacy lawyer, and she said, it'll never be able to do a privacy playbook like I do with my California clients. And so we sat at my kitchen table downstairs. And I said, you represent a company that's a retailer. Build a privacy playbook for California law. And here's the output, saying things like, how are you processing data? Who is receiving that data? Are you minimizing it? Are you dealing with GDPR? And also, if I, as a data subject, can I access my data? Delete, opt out? Do you discriminate? What are the procedures? These are all things she said, my friend said, these are all things I would do on day 1. Then I followed up by saying, tell me how a California retailer would implement that bullet point. And she said, these are all the things I would go through with my retailers. What are your names and addresses for loyalty programs? Are you collecting purchase history for marketing? Are you collecting web browsing data to personalize the content? Another problem you can solve is letters to cease and desist. Stop doing this thing that is unlawful. And so here is a cease and desist letter from a woman named Debbie Downer, who said, Damien, stop wishing me a happy birthday. And I responded with a large language model saying, respond to Debbie in a way that is pleasant but firm. Tell Debbie to chill out, but do it professionally. And here is the output. Accept my apologies. I didn't intend to harass or disturb you. I will respect your wishes, but we should resolve our disputes respectfully in a more tempered manner. We should be collaborative, chill out, but professionally. You can create chronologies. Who did what when? So here is a complaint. I said, put who did what when into a table, and it creates a very nice table. And a lot of lawyers say, well, AI is good for old questions, but I have a lot of new questions that have never been decided by the courts. And to them, I point to a friend of mine who said, Damien, can you tell me how about effective computing? Because my call center, an insurance company, is thinking about using effective computing. And so we used AI. I said, define effective computing in insurance and the law. And here's the output. Effective computing is how computers recognize emotions, either through facial expressions, voice patterns, to create emotional aware conversational agents. So I said, now tell me how it might be used in an insurer's call center, because that's how my friends was thinking about using it. And here's the output. You might be able to recognize the caller's emotional state through their speed of speech and figure out whether the caller is emotional due to their accident. And then I said, now give me a list of legal issues that might result. And ChatGPT responded saying, have you thought about privacy law and GDPR and CCPA? Have you thought about whether the callers consented to you obtaining their emotional data? Have you thought about what if you get hacked and now all of your customers' sensitive emotional data is in the hacker's hands? These are good legal and practical considerations. And again, it took just a few seconds. I said, now create sub-bullets of other facts. And it happily created many sub-bullets talking about where did they call from? What are the types of data? So this is an ideation machine where you could just be able to build and build and build. And what if you bake everything I just showed you into legal software? So you as a user don't have to be a prompt engineer. I'm a prompt engineer. Maybe you don't have to. The best way to predict the future is to create it. I litigated for 15 years and I wanted better systems. And here we are today with better systems. So in vLex, you simply upload a complaint. And Vincent does everything I did as a litigator for every single complaint I received. I said, what are the claims in the complaint? Is this a breach of contract or patent infringement? What are the facts supporting those claims? Who are the parties in this case? What are they looking for? Are they looking for money, or are they looking for an injunction to stop the thing from happening? These are all extractive tasks, and we give this to you, no prompting necessary. And then beyond extraction, we go to ideation, giving ideas. What are good legal defenses for each of those claims? What questions should I ask my client to help them win? This is the work of the lawyer. And we're giving this to users, no prompting necessary. And then beyond these tasks, we also give legal research questions that are customized to this particular complaint. Because it's a copyright complaint, Vincent says, maybe you want to know about statutory damages and actual damages. And it's given me 5 other legal research questions, again, customized to this complaint, no prompting necessary. And so to the point of agents, is this an agent? And I would say that it is, because I would say that an agent, depending on how you define it, is something that takes a document or takes information and decides what to do with it in an intelligent manner. And an agent puts together tasks, strings together tasks that get the job done. So this output of what you see here is about 200 pages worth of output. And those 200 pages would have taken my associates at Robbins Kaplan probably about 200 hours to be able to do this work. Vincent does it in about 5 minutes. And so is this an agent? Probably, because it's strung together tasks in a very intelligent way. And this is for a litigation example, a complaint, where I give you the copyright infringement analysis. I give you defenses to it, like fair use. I also give questions to ask your client. Hey, OpenAI, what was your training data? Did you get permission from the New York Times? But this is not just a litigation workflow. This is also a transactional contract workflow. Because if you upload a contract, Vincent recognizes, oh, that's a merger agreement. And we give you different buttons, different tasks. Again, no prompting necessary. And these buttons reflect what contract lawyers care about. Give me all the definitions. Give me overlapping clauses. How can I mitigate risk? What is language that is client hostile? Give me post-closing obligations. Give me fallback positions. How do I comply with the regulations? Who needs to do what when? Again, is this agentic? Under some definitions, yes, because it understood that this is a contract. And then based on that, it gives you different tasks that you could be able to string together in an agentic way. So you might say, gosh, this is amazing, Damien. And I would agree with you. And then you might say, how long has this been here? And we've had what you've seen here for over a year, actually almost 2 years. And so the future is here. It's just not evenly distributed. So when we think about agents, there is, this goes to Danny Kahneman, who is a very influential psychologist who sadly died a few weeks ago. But he talked about system 1 thinking and then system 2 thinking, where system 1 thinking is what large language models used to be back in 2023 and 2024, where they give fast, subconscious, automatic responses in 1 minute, much like we as humans would say 1 + 1 equals, immediately we say 2, right? That is system 1 thinking. But system 2 thinking is more slow, conscious, and effortful. So for example, who should I marry? Should I take this job? This requires deliberation and it requires thinking through. And most legal tasks are this system 2 thinking. And this is where agents come in. And so maybe it takes 5 minutes, but as a result, it's more reliable. That is, you're able to give a better thing than maybe the hallucinatory large language models in system 1. And so when people talk about agents in the world, they're often talking about this. They're saying, hey, I want my agent to start a business. So the robot goes out and creates a business plan, creates a business structure, creates a product, creates a bunch of advertisements, creates a bank account, brings in money. And if you have any questions about robot, just let me know. Bad things can happen here. Think about all of the laws that these robots can break, and think about all of the loops that, maybe the robot reaches a dead end. So this is what everyone is talking about with large language models. But when we think about legal tasks, there are a lot of things that we already know. When you think about the most common legal tasks on the left-hand side, and then think about the less common and unknown tasks on the right-hand side, this is a head and a long tail. And so for the head, maybe you as a human and I at vLex can be able to figure out what those most common tasks are and let robots achieve those tasks. And then for the less known, uncommon matters, you can let the robot figure out things and maybe have the large language model, and then have a human give a thumbs up or a thumbs down, and then have the large language model complete that task. This is the way that the smartest people in legal technology are doing their work. Because between option one, an agent, you as a human saying, I want my goal, and then the robot defining what tasks need to be done to achieve that goal, and then the human maybe giving a thumbs up or a thumbs down as to that, and then the robot executing the tasks, and then achieving those goals, a lot of bad things can happen there, because the robot might not know all the tasks that you need to do for that legal work. But in contrast, what if you as a human both define the goals, and then we at vLex define the most common tasks for that goal, and then let the robot execute the tasks at superhuman speed and achieve those goals at superhuman speed and at a postgraduate level? So between these two options, the end user doesn't care which is which. To the end user, both sides are magic. But the difference between the left-hand side is the left-hand side is reliable and the right-hand side is unreliable, because it might do the tasks here that you don't care about. But here, if you define the tasks saying that I, as a litigator, every time I do this, I do all these tasks, or as a contract lawyer, I always do all these tasks, why would you let the robot figure out what those tasks are? Why don't you let the humans do that? So when you think, that's what we at vLex have done, is we've taken all the most common known tasks here and we've made them reliable. And we also include the robots suggesting other tasks for the more uncommon and more unknown. And imagine, what if you took this line between them and you move them over to the right, and then take the most common robot created tasks and throw them over to the symbolic side, the reliable side. This is the way that you could be able to get reliability, predictability, rather than the large language models being less reliable. So the example that I showed earlier is, you take a complaint. Here are all the tasks that are here, both the tasks like extracting claims and the tasks like legal research. What I didn't tell you before, though, is that I, as a human, along with my team, figured out what these tasks were. But this task about legal basis, the robot came up with that. Vincent came up with that on its own. And the questions about legal research, again, Vincent came up with these on their own. So the real winners in this game are going to take human-created tasks, therefore predictable tasks, on the left-hand side, and then large language model created tasks on the right-hand side, and putting them together. That is the way, because then you have the best of both worlds. You have predictability on the left-hand side, and then you get the long tail and ideation on the right-hand side. So you might say, well, tell me, I know that I heard a lot about hallucinations. How should I think about hallucinations? And that is the biggest obstacle for lawyers not adopting it. But the question is, compared to what, or compared to whom? Because this is a study from 2023 where the researchers had a human summarize a document, and then they had a large language model summarized the same document. They mixed up the results, gave it to human reviewers, and the human reviewers said that the humans hallucinated more than the machines. That is, the humans got the facts wrong more than the machines got the facts wrong. And by the way, this is back in 2023, and hallucinations have dropped drastically since then. Here's another study showing the same thing, that LLMs are either equivalent or superior to humans from medical experts. That was from 2024. So that is true only if you have the law. That is, if you can summarize the case, the statute, and the regulation. If you have that case, that statute, and the regulation, then the rate of summarization of that, right now with the large language models, the machines do it better than humans, even today. And this is the worst that technology will ever be. That is, the machines are more factually consistent than the humans. Another study, the machines are better performing than the humans are. And the reason for this is because in Watergate in the United States, this man, John Dean, testified as to what happened during Watergate. And before he knew there were audio tapes recording everything, he testified. And he got some things wrong. For example, he got wrong who said what. Well, what he got right is kind of directionally the gist of what was being said. And that's because we as humans, every time we remember something, we build that memory again. It's not like a database where we retrieve that memory, but actually each time we remember something, we regenerate that memory. And that's why the fish that I caught started out this big. And the next time I remember it, it was this big. And then the next time I remember it, it was this big. That's because every time I'm regenerating that memory. So we've known this in psychology for many, many years. And that's really how large language models do it too. Large language models regenerate every single time. And just like humans, they sometimes get it right and they sometimes get it wrong. So if you were to ask one of the best linguists of the 20th century, Noam Chomsky, you ask him in 2025, tell me about the book you wrote in the 1960s. He is probably going to hallucinate. That is, he's going to get some things right, some things wrong, but he's going to be pretty confident in what he's done. So that's option one. Option two is to give Noam Chomsky 2 pages from that book and say, Noam, summarize these 2 pages. And he's going to be much, much better because now he has those 2 pages right in front of him. So he can do a much better summary of those. So what if you have the case right in front of you, or the statute right in front of you, or the regulation right in front of you? How much better can a human do? And how much better can a machine do? The large language model. So between asking a large language model, say ChatGPT, a question, it's going to hallucinate. But if you say, hey, ChatGPT, here is yesterday's case, yesterday's statute, yesterday's regulation, it is going to do much better. And the rate of hallucination will be better probably than humans. So AI alone is not a search engine. But what AI does is analyze content. And if you give it the cases, statutes, and regulations, the law, it can do a much better job analyzing that content. So if you want to be able to give, between the large language model giving them a closed book exam versus giving a large language model an open book exam, why would you ever use a closed book? Why wouldn't you give an open book exam where the large language model has access to the cases, the statutes, and the regulations? Here are a few documents. This is what's called retrieval augmented generation, otherwise known as RAG. And that's what we do here. The text you see here will 100% of time be non-hallucinated. That is, this case will be non-hallucinated 100% of the time. And this text from that case, the excerpt, will be non-hallucinated 100% of the time. Not 90, not 99, but 100% of the time, this will be non-hallucinated. And you might say, Damien, I've heard about large language models. How can you say 100% and not 99%? And I can say 100% because the text you see here was not created by a large language model. This text was a database search, like we've been doing database searches for 40 years. So 100% of the time, this text will be non-hallucinated, and 100% of the time, this case will be non-hallucinated. And we at vLex have been collecting the cases, the statutes, the regulations in 100 countries worldwide, including in the United States and including in Latin America. So you need that ground truth, the text, for the large language model to do retrieval augmented generation on that text. The A, the retrieval augmented, that is added, the A matters because only when you could be able to add our structured data to the plain language question. Here I've asked about how long it would take for a civil rights case to settle in the Central District of California. If you were to ask this of ChatGPT out of the box, it would hallucinate all over the place. But because we have the case data, and because we have the fact that it's a civil rights case, and we know when it was filed, and we know when it was terminated, and we know that a stipulation to dismiss the case usually means that the case has been settled, we have this data on the screen here. And when you combine this case with a bunch of other cases, we can then give you an authoritative statement that some cases settle in 12 days, but most of them take about a year and a half. Because we have the data, the rate of hallucination is pretty close to zero. And in any case, better than humans, if you have the data. But if you don't have the data, if you don't have the cases, it's going to hallucinate. But because we do have the data, the rate of hallucination is much, much smaller. It's only because we have this data that you can give a good answer. And how many companies in the world have good data for Latin America? How much do our competitors care about Chile, Colombia, Brazil? We have been in Latin America for decades. So we care about Latin America. So let's talk about the business of law and how all of this agentic work affects the business of law. And we've been thinking from a lawyer's perspective, but let's think about the client's perspective. So option one for the client is they ask their lawyer a question, and maybe they assign an associate, takes a couple of days. Maybe the bill is a few $1,000s. And the client trusts their lawyer, so maybe 95% confident in their human partner. That's option one. Option two is to not ask the partner at all, but use a large language model tool, like say maybe Vincent. Ask them a legal question, and it's not going to take 2 days. Literally takes 1 minute. Not going to take $5,000. It just takes pennies. And the in-house, the large language model beat 90% of the bar exam. So the question is that 5% between 90 and 95%? And is that $5,000 in 2 days? Is that worth it? And the option one lawyer is never going to know why the phone didn't ring. I talked to many, many in-house counsel that say every time I thought about asking a question of the law firm lawyer, I just use Vincent. And Vincent gives me a really good question or give me a really good answer to my question. And then I asked the business person, do you want me to follow up with a lawyer? And the business person said, no, I think this is good enough. And that lawyer, the partner, doesn't know why the phone stopped ringing. I gave this talk in New York to one of the biggest law firms in the world. They make annually about $2 billion a year. And that partner said, Damien, I don't want $5,000 matters. I want $5 million matters. And I responded, I said, I worked $5 million matters. And you and I both know that those are filled with $5,000 tasks. So if you're an in-house counsel, how much will you put up with a $5,000 task being used, spending $5,000 when that in-house counsel can say, hey, I can use Vincent to do that for pennies. So there was a study between large language models and humans where the task was reviewing a contract. And this is back in 2023. And even then, humans were 93% accurate and the machines were 95% accurate. And the humans took up to 200 minutes, where the machines took up to only 4 minutes. The cost per document for humans was up to $76, and the maximum for the machine was $1.25. So already back in 2023, it was 300 times cheaper to have a machine and gave better performance. So the machine was both better, more accurate, faster, and cheaper. Now, in the old world, there was a joke that wasn't a joke, saying better or faster or cheaper, pick two, because you can't have all three. You can have better and faster, but not cheaper, or you could have faster and cheaper, but not better. But here, you could actually have all three. It could be better, faster, and cheaper. And so this is the world that in-house counsel are thinking about. This is a consulting group, Harvard, with Boston Consulting Group, said that the human consultants with GPT-4 completed more tasks faster and at higher quality. Better, faster, cheaper. This is another analysis, another study by my friend John Choi that said they did better on contract drafting. Machines did better in complaint drafting. Machines did better in other drafting. So when we think about the business of law, most partnerships, most law firms have a 1 partner to 4 associate ratio. But the real question is how long before that 1 to 4 turns to 1 to 3, 1 to 2, maybe to turn into 1 lawyer, 1 matter, where the partner just has their friendly large language model where they ask questions and does work faster, better, stronger than any associate could. So we'll call this world number 1, where you just fire all the associates. And I hope we don't do world number 1. I hope we instead keep all of the associates and let those associates be able to use their large language model agents, like Vincent, and then be able to both steal the work of other competitors, competitive law firms that haven't figured it out, so go laterally to be able to eat market share from their competitors, then also go down market, because a lot of clients can't afford us lawyers because we're currently too expensive. But an associate with a tool like Vincent, maybe you can give more affordable legal work. And so in the United States, for example, 92% of legal needs are unmet because we lawyers are too expensive. So maybe the associates in the United States and maybe the associates in Latin America can use large language models to be able to capture some of that value, to capture some of that 92%. Because economists would call that 92% a latent legal market that is just waiting for somebody to be able to tap into that market and get some of that revenue. Now, there's an old joke that the slowest lawyer wins the race. That is, if you spend 8 hours doing something that I spend 1 hour on, you make more money than I do. But that slowest lawyer wins the race is only true for hourly lawyers. You know who it's not true for is contingency fee lawyers. I don't get paid unless you get paid. For flat fee lawyers, I'll do this flat fee. I'll charge you this much for a subscription. Every month you give me a certain amount. Or if I win, then you get this. Also for corporate in-house law departments, they love efficiency. Also government lawyers, attorneys general, prosecutors, public defenders. For all of these people, there's more work than there is time. Therefore, they love efficiency. They love Vincent. So the question is, if you show me the incentive, I'll show you the outcome. If you incentivize hours, I'll give you more hours. If you incentivize efficiency, I'll give you more efficiency. But the problem is with the hourly, you're incentivizing hours. And also, you as an hourly firm think mostly in terms of revenue. How much money did you bring in last year, last quarter, etc. But what you don't think about as much is how much did it cost to do this? What was your overhead? How much did you have to pay your associates? Because revenue minus cost equals profit margin. But what if you go from the hourly side to the flat fee side? Now, if you push down your cost using AI, using Vincent, you then make more money. And in fact, you make so much more profit that you can say to your clients, I'll give you a tiny haircut of what I would have done, what I would have charged you hourly. And the client says, wait, not only do I pay less than I did in the old world, but I also get a certainty of a flat fee. sign me up. And the thing is, if the clients don't know what that top line is, you can actually push that top line up and actually make more money and more profit. So then it just becomes a negotiation with the client to be able to say, what is that top line going to be? And what is your profit margin going to be? That's a negotiation. But you only get there if you move from the hourly side to flat fee or contingency fee or some other way that you're not incentivizing hours. You're just incentivizing efficiencies. When I was a lawyer, I did plaintiff side antitrust work where I would sue over price fixing cabals. And competitors would agree to a price, but almost inevitably, one of those competitors would drop their price. What would happen next is they would steal customers from all of their competitors. And then once that happened, all of the competitors would drop their price too. This is how price fixing cabals go away. As lawyers, we don't have a price fixing cabal, but we kind of have an hourly billing cabal. And I talk to many, many law firms that say, we have gone to flat fee, we've gone to subscription fee, we've gone to these alternative methods. And they say, we're stealing the lunch, we're stealing the customers, we're stealing the clients from all of our competitors. And what happens next is, of course, everybody's going to have to go this way. And again, it's not going to be 100% flat fee, but maybe it goes from 10% flat fee to 20 to 50 to 60. But once you do that, you can eat the lunch of your competitors. And the question is, do you want to be law firm number one that does this and eats the lunch of your competitors? Or do you want to be this last firm where you can blame all sorts of things? You can blame the economy, you can blame the client's, sweetheart deal with the other lawyer, but you won't know why the phone didn't ring. You won't know it's because your competitors are doing things in a more forward manner that the clients don't want to tell you, that they stopped hiring you because you're treating the law like it was in 2020, rather than the way the law is in 2025. So do you want to be law firm number one, or do you want to be the last one? So when you think about the potential worlds that we're going forward, the future is hard to predict. But in 2022, we knew what the world looked like. In 2022, you had a workforce that worked 40 hours a week, usually more. Then you paid them a salary to be able to give 22 levels of productivity. But that's not the world anymore, because today we have large language models. And I know coders that have multiple jobs, and they only spend a fraction of their time with that job, and they give 22 levels of productivity. That is, they have 2 jobs or 3 jobs, and their employers are happy. That's not going to last. What a law firm is probably going to do, and what businesses are probably going to do, is to say, no, worker, you're going to give me 40 hours. And then as a result, I, as a business, am going to reap the benefits of your increased productivity. So that is in world number 2. World number 3 is maybe you fire a bunch of people, and then whoever's left works 40 hours a week. And then you settle for maybe 2x or 3x productivity. These are 3 different worlds. That is world number 1 is a don't ask, don't tell world. World number 2 is a world of abundance. And world number 3 is a world of scarcity. And depending on the day, I vacillate between which of these 3 worlds we're going to end up in. I worry that we're going to be in scarcity, but I hope we're going to be in world of abundance, where we're going to keep all the workers. They work 40 hours a week, and everyone, the world economy just booms because of this business. And what I think this happens to relates to law firms is Peter Deng, who led up ChatGPT, said companies will get smaller. He said the number of 10,000 person businesses, he said, what's to keep maybe 5 people from jumping ship, starting their own companies, and then they use their 10,000 large language model agents underneath them to do the same kind of work that a big company did. And I think he's probably right. And now replace the word business with law firm. What if you have a big law firm Where in the old world, you needed to have the secretaries, and you needed the big real estate, and you needed to have the word processing department, and you needed to have the offices. But these days, lawyers do almost all that work themselves. So what's to keep 5 lawyers from jumping ship from these big law firms, working from home like everyone's been working from home in the past, and using their large language model agents, like Vincent, to be able to make more money than they ever did with the biggest law firm, but instead be able to do it, work fewer hours, because it's much easier for this tiny business to decide we're going to be all flat fee. Much harder for the big business, the big law firm, to say we're going to be flat fee, because the billable hours allure. Billable hours hard to leave. So when there's a study, knowing we have 4 minutes left and we want to leave a little bit of time for questions, there was a study where Lexis asked law firms, do you think your clients expect their bills to be reduced? Only 10% of law firms thought the clients expect their bill to be reduced, but 80% of corporations said that they wanted their bills to be reduced. This here is a disconnect. Law firms don't understand what their clients are demanding. And for the law firms that don't get it, clients are going to vote with their feet. That is, most of the law firms have already adopted AI in some capacity, and most of all generations are open to their firms using AI. And firms that are AI native can make more money. And this is a study from a venture capital firm. And so we also have to think about alternative legal service providers, that is, non-lawyers getting into the legal business. And maybe they're going to displace more law firms. Because as a big law, you have an associate here that works with the first partner who bills by the hour and the second partner who's flat fee. The big law has a hard problem, because come December 31st, how do you compensate that associate? You compensate based on hours? Because if you compensate based on hours, you make the partner 1 a lot more money. But if you compensate, if she does 3,000 hours, that's costing the partner 2 a lot of money. So how can she serve both? That's the dilemma of big law. But ALSPs, law companies, and small firms, they don't have that dilemma. They can say, no, we're all in on flat fees, and we're going to shrink our costs with AI and be able to increase our profit margins. So there's also geographic labor arbitrage. You in Latin America, your costs are cheaper than in the United States. So maybe you could eat some of the lunch of your Miami counterparts, or some of your Arizona counterparts, or California counterparts, and be able to make more money than your United States colleagues. So I think that's probably, we have 2 minutes left. Fernando, are there any questions that we should be addressing?
Yes, thank you, Damien. There are a good number of questions. Let me raise the first one. Amel Martinez asked, Damien, do you think the way we approach problem solving as attorney needs to be restructured to better align with artificial intelligence reasoning? Are we perhaps transferring the inefficiencies of traditional legal thinking into artificial intelligence through our prompting? If so, how may we bridge that gap? Sorry.
Yeah, I think, that's an excellent question. And I think that, the question really goes to, is inefficient prompting leading to inefficient results? And this goes to me saying, if I'm doing my job correctly, you won't have to be a prompt engineer. Sam Altman, the CEO of OpenAI, was asked on stage, what do you think of prompt engineering as a field? And Sam said, I hope prompt engineering is not a thing in a year. Because if I'm doing my job correctly, you won't have to be a prompt engineer. You simply ask me a question and ChatGPT will give an answer. So we at vLex agree the same thing. As a lawyer, you should not be a prompt engineer. You should simply upload a complaint or upload a contract or ask a simple question. And what you won't see on the background is the 35 prompts, 40 prompts, 60 prompts that we do in the back end to make your results better, even though you've given maybe an inefficient prompt on the front end. So if we're doing our jobs correctly, you won't have to be a prompt engineer. You simply ask a question as inefficient as it is, and we will give you an efficient answer to that inefficient question. So I think that both with what Vincent is doing and with what the AI generally is doing, that is OpenAI's AI, Google's, Amazon's, they're all creating thinking models that are essentially going to root around the inefficiencies of the question. So I think that's a good question, but if we're doing our jobs correctly, you won't have to worry about efficiencies in your prompting.
There is another question from Renato Bacaro that says, I have heard that in some places, clients already come with a legal answer to their problems and ask lawyers only to review and to sign. If most litigating lawyers have these tools and market saturation, will lawyers just be good for court appearances?
I think that is a, you're not going to have a robot standing in front of the judge anytime soon. So court appearances is going to be something that it will be a long, long time before the robots do and the humans don't. So I think there's job security for litigators. But to the other question, the clients coming to the lawyer with a result and asking the lawyer just to validate that result. I'm already seeing that today. That is, I sell to the biggest law firms in the world, and I also sell to the biggest corporations in the world, the Fortune 100 and Fortune 50. And what some of the people in the corporations say is that what they do is they upload complaints that they received in the past year. And then they compare the 200 pages worth of analysis that Vincent gives with what their lawyers did. And then they say, what did the lawyers do on top of Vincent's 200 pages, if anything? And what did these Vincent's 200 pages have that they wish their lawyers had told them? And if it's a lot, that's going to say something. And then they say, going forward, for new complaints they receive, and this goes to the audience question, for new complaints they receive, before they give those complaints to their lawyers, they're going to run it through Vincent, then take Vincent's 200 pages and give them to the external counsel and say, what can you do on top of these 200 pages? Because that's all we're going to pay you for. We're not going to pay you to recreate Vincent's 200-page wheel. So I think this is already happening. There's a saying, the future is here. It's just not evenly distributed. And there can be debate as to how widely it's going to be distributed and how soon that distribution will be. I think we can all agree that it is inevitable. If we say, is it going to happen in 50 years? Of course. Is it going to happen tomorrow? No. But now we're just quibbling over how long it's going to take and how much market share lawyers are going to lose if they do things in the old world.
Before we continue with a couple of questions, I invite all the participants to answer a survey that we are going to post right away, because that will help us quite a lot for our next master classes. The following question is the following from Jose Lopez Segura. On comparative law, artificial intelligence can solve consultations based on different legal systems. For instance, to move from the Anglo-Saxon system to civil law system?
Yes, is the answer. And so for that, I'm going to go back to sharing my screen and give, we as lawyers like evidence rather than just speaking. So I will give evidence. Here I've asked about privacy laws related to online advertising. This is something that is important both to Latin America and to the United States. And I've asked this question across the United States and the United Kingdom and Ireland, Spain, Portugal, France, Italy, the European Union writ large, Brazil, Chile, Colombia, Mexico, Hong Kong, and Singapore. And so you can see here that there are some common law countries here, and there are some civil law countries here. And so what it's done is it's gone through all of the cases, the statutes, and the regulations for example, we'll go to Chile. And it's given me a one-paragraph answer in English. And it's gone through all of the cases, the statutes, and the regulations, and the secondary materials that answer my question about privacy laws related to online advertising. And it's done a trick that nobody else does, where it's taken my Spanish text from Chile and then given me an English answer. And it's done that because I've set my language settings to English. I could have just as well set it to Spanish, or to Catalan, or Italian, or French, or Portuguese. So to be clear, you could ask a Spanish question across Italian law and get a Spanish answer. We're the only ones that allow this. And so now you can do that cross jurisdictional analysis for the UK, Spain, Portugal, et cetera. And then what we do is we provide a table at the bottom with the United Kingdom's Data Protection Act, Spain, Portugal, France, and here's Chile, Colombia, Mexico, others. And we have all of the particular statutes, whether it requires consent, transparency, opt-out, et cetera. And then I can download that as an Excel spreadsheet or as a CSV file. And once in Excel, you can sort, filter, and do all the things that you would like. This kind of work in the past might have taken weeks or months, but this literally takes 5 minutes. So you can do that cross jurisdictional analysis.
Very good. Your answer already answered other questions related to the to what Vincent could do vis-a-vis the information it has in the system. But there is another question from Francisco Gonzalez that says, Vincent is based on OpenAI agent or proprietary model of vLex?
It's a good question. And we have a mix of both. In the industry, we call this an ensemble of models, much like you have an ensemble of musicians. And that ensemble of models mixes proprietary with OpenAI's. So for example, I'm going to go again to Chile. So here, to do stage 1 of this, to find the text, that is a proprietary model. That is, we have what's called a vector embedding model that pulls out the most relevant text to the user's question right here. So this is proprietary. And then to do this, which is an analysis of how this case or this case answers the user's question, this that you see here, we can use whatever model is best. So we often use OpenAI. Sometimes, though, we use Gemini from Google. Sometimes we use Anthropic from Claude from Anthropic. And so we really are agnostic as to the best model for the job. As the models keep competing with each other, we will swap in the model that works best. So to answer the user's question, proprietary models and whatever large language model is best for the job.
Very good. Another question refers to from Bardo Untiveros, with so powerful models currently existing, do you think LLMs used for legal agents still require fine-tuning or RAG or both?
So between fine-tuning, RAG, and both, I'll start with both, right. So with fine-tuning, there was a study that took a fine-tuned medical model, that is something that was trained just on medicine, and compared it with GPT-4, which is just a general model that has all the internet. And GPT-4 beat the fine-tuned medical model. It did better than the fine-tuned. So, and the problem with fine-tuning is you're stuck in time. That is, if you fine-tune something in 2023, then when the better investments comes in 2024, this is already out of date. In the fine-tuning, you spent $1 million for something that doesn't work. So between fine-tuning and retrieval augmented generation, RAG, number 2 is much better. Because you could be able to use the best model, GPT-4, O1, O3. And because you have the cases, the statutes, and the regulations, you can use O3's better reasoning model on those cases, statutes, and regulations. So you get the best of both worlds.
Federico Ramirez asks, what difference could there be between ChatGPT in reasoning or research mode and Vincent in terms of the quality of the response after analyzing the claim?
Sure. And the question for that is, does ChatGPT have yesterday's case in Chile or Colombia or anywhere in Latin America that matters to you? Does ChatGPT have those? And so that's question number 1. Do you have the case or statute that was passed yesterday? Number 2, do they know whether this is still good law or not? So for example, does ChatGPT know that this new case from yesterday overruled the old case that ChatGPT doesn't have? So what we call in the industry a citator, to say that Roe v. Wade is no longer good law, but has been overruled by Dobbs. This is a citator that I would guess that ChatGPT is not going to have anytime soon. So number one, does ChatGPT have law from Latin America? And number two, do they have a citator to see what is old law versus what is good law, the new law?
Okay, another question. Diego Andrés Ortiz asked, that means just if the artificial intelligence is operated for a human, the artificial intelligence could be more efficient than man. But a professional have to do a properly prompt for the artificial intelligence. That is the only way. Otherwise, the artificial intelligence could be imprecise.
Maybe. So let's look at the three scenarios. One is the human alone. The second is the machine alone. And the third is the human plus machine. Okay. And we've already known this for chess. We've known this for decades, right? So you had the human and the machine. Humans lost to machines in Garry Kasparov in the 1990s, right? But then after that, they went to number three, where the humans plus machines actually beat the machines alone, and they beat the humans alone. So it's the combination of the two, human plus machine, that does better than 1 and 2. That was with chess. And for a while, I think that's going to also be true for the law. That is, the humans plus machines are going to do better than the machines alone or the humans alone. And the question is, for how long? A friend of mine from Minnesota and Michigan, they are professors that did a double-blind study where they had the machine alone, the human alone, and then they had humans plus machines. And right now, the humans plus machines did better than either the humans or the machines alone. But the question is, for how long? Because today in chess, actually the machines beat the machines plus humans. And also there's another study where doctors, the doctors with AI, they had doctors alone, doctors with AI, and the AI alone. The AI alone beat the doctors with AI. And the reason that the AI alone beat them is because the doctors would overrule the AI, thinking that they knew better than the AI, but the AI actually got it right and the humans got it wrong. And that is today. So the question is, how long before humans plus machines are actually beaten by the machines alone? Because we humans haven't read the entire internet and we haven't read all the cases. So there's a real question as to how long that's going to be.
Okay, here we go with the last question because we are reaching our time. And I will put them together. Does vLex protect the confidentiality of the documents uploaded to the platform? Number one. And number two, in your opinion, which are the most sound and recommendable systems for the legal sector?
Yes, if you go to trust.vlex.com, as I'm here, you don't need to be logged in, and you will see the ISO security certification and the SOC 2 Type 2 security certification. And what the questioner is asking is actually three questions. Number one, is my data secure when it's being uploaded? And this security certification has people, third parties, saying, yes, data is secure. That's number one. Number two, a question people ask is, does vLex train on your data? And the answer is no. vLex will not train on your data. And then question number three, does OpenAI or Google or anyone else that we are partnered with, do they train on your data? And the answer is no. We spend a lot of money to make sure that that answer is no. So number one, is the data secure? Yes, it is. Number two, do we train? No. Number three, do others train? And the answer is no.
Okay, excellent. We have come to an end to our class. Once again, Damien, thank you very much for accepting the invitation for this masterclass. As we discussed before we started the class, the changes are moving so fast that it's not easy to keep the pace with the changes. But there is no doubt, in my personal opinion, that nowadays there is no doubt that the business of law is going to change, and it's much better that law firms and lawyers start embracing the change and start working in reviewing their business model, bringing artificial intelligence to, as we discussed, become more efficient, more reliable, more productive. And this should not be done from one day to the other. This takes time, and that's why a strategy is essential, no matter which is the size of your firm. So once again, to all those that attended the class and have stayed with us, thank you very much. We will continue with our regular master classes together with vLex and Damien and other well-known representatives from vLex. Thank you very much and see you next.
Thanks, everyone.